Please rise. Justice of the Appellate Division, Supreme Court, First Department. Here, all persons having business with the appellate division draw near. If the attendant shall be heard. Okay. All right, good afternoon. Oh, did we say something that, where's everybody? We have, according to the notes here, more than 4 hours of argument time. Boy, you guys are asking a lot of time, but we'll see where we go from there. Good afternoon, everyone. Welcome to the First Department. You know the standard speech. We have read your cases. We know, get right to the heart of your arguments. The clock is for you, not for us. And having said that, first case up, People versus Omar Johnson. Oh, submitted. Wow. Ooh, okay. All right, next case, People versus Aaron Garcia. Is there a lock on the door?
That was submitted.
That's submitted too? Gerard, you put a lock on the door or something? Case number 3, Lenar versus Massachusetts Mutual. Ah, thank you. 6 minutes? Ah, okay, you said the key word, 6 and 2, you said? Yes. 3 and 2. And the respondent?
5 minutes, please.
5 minutes. Okay, so 6, 2, 3, 2, and 5. Thank you. Triumph Enterprises versus Webster Auto. Yeah, that's right. Thank you. All right, case number 5, 1140 LLC versus My Studio. You're the, oh, there we go. 4, 2, and 2. Okay. Case up, Desprez versus United Prime. It's submitted. Omar Service versus Sahara Plaza.
Respondent.
Any appellant want to submit? Thank you, submit it. What day of the week is it? All right. Sticky's Holding versus Abrahamian. 5 and 1. 5 minutes. Okay, 5, 1, and 5. Thank you. People versus Nathaniel Linden. That's submitted. Duha versus Martinez.
Your Honor. 3 and 2.
3 and 2. 3. Okay, 3 and 2 and 3. Thank you. All right, Patrick Capital versus Rabina Properties.
Good afternoon, Your Honor.
7 and 2. 7. Okay, 7, 2, and 7. Next case, Ramjohn versus Major Development. You want to submit? All right, thank you. That's submitted. 13 is M&A Infant versus Spring. That is the non-numerated. That is submitted also. First case up is Lenar versus Massachusetts Mutual. Okay, go ahead, counsel. Thank you.
Good afternoon, Your Honors. May it please the court. My name is Joseph Orlando for the appellants Mass Mutual and Capital Builders. The very limited issue on this appeal is the scope and breadth of the phrase readily available, as coined by the Court of Appeals in determining whether a safety device was provided to a worker under labor law in compliance with Labor Law 240. In this particular instance, the work involved the renovation of multiple apartments.
Okay, he was standing on a stack 5-gallon plastic. You can have a seat. You don't have to stand for it. Okay, he may be a while, so. not that long. He's standing on a stack of 5-gallon overturned containers, right? Plastic 5-gallon containers. We know what those look like. And he fell off of it.
Correct, Judge.
Plain and simple, no dispute. I mean, that's what we that's what we have in the record here, right? And the
Yes.
question is whether or not he knew to go get a ladder, right? The ladders were in the shanty,
Correct.
right? He gives the deposition testimony where he says that he told his foreman Maddox or Madden, right?
Yes.
That he needed a ladder, and he testified that Madden says, continue what you're doing, I'll go get you the ladder. And the ladder, he testifies and he never gets the ladder, and he falls off the buckets.
That's his testimony.
Then Madden's testimony, he doesn't recall ever being asked, or he doesn't recall the conversation. Doesn't that, how do you not recall a conversation like that? I mean, he
If it didn't
recalls
take-
everything else, but that one part, when you get to the ladder, he just doesn't remember. But he remembers everything else about what happened that day.
Well, if the conversation didn't take place, then he didn't remember having the
Well,
conversation.
that's not the same as saying I never had that conversation. He's just saying he didn't recall. So that's in my mind, that's very different as saying what you just said, that, the conversation never took place. Those could have been his exact words. I don't know what he's talking about. That conversation never took place.
Right, but
never said that.
regardless of that, he did.
Well, you can't say regardless of that. That's a pretty big, I mean, you already pointed it out. So this is something about whether or not he got what he readily available commentary, right?
Well, moving,
I
think
I'm just reading what I have in front of me.
I understand,
I told you
Judge.
we read everything.
I understand. If he asked for it, Mr. Madden, I believe that the testimony was that Mr. Madden never had a conversation like that with plaintiff. Now, I may be mistaken, but I could have sworn that Madden said that conversation never took place. Plaintiff never asked him for a ladder because the ladders were available in the room where they had the morning meetings, and he had specifically told the plaintiff through a coworker translating, if you need a ladder, here they are. Use
But
one if you
didn't
need one.
plaintiff also testify that there were more people, more workers working than there were ladders available, at least on that day, those days that he was working?
He may have said that, but Madden also said that there were a sufficient number of ladders for the workers that were working there. So you have complete contradiction in testimony between plaintiff and Mr. Madden, his foreman.
But on the pictures that I saw and the commentary that people made when they were shown the pictures, they never did see a ladder in the room where he fell. I mean, I saw a picture of where he fell, but there was no ladder there.
That is correct, Judge. The ladder was located within a few floors, within 4 floors, per Mr. Madden, from where the plaintiff was working, and all he had to do was take an elevator down to that floor or up to that floor to retrieve the ladder. The room where the ladders were stored was unlocked during the workday. Ladders were not chained up, and he had specifically told plaintiff that if you need a ladder during the day, just go to the room and grab one if you need one. So according to Robinson and Gallagher, as well as Montgomery, the ladders were available. There was a ladder available to the plaintiff. There's a question of fact, in the very least, as to whether the plaintiff was a sole proximate cause here for not availing himself of the ladder that was available to him.
Counsel, I know that your understanding of Madden's testimony is maybe different from someone else's understanding, but do you agree that if Madden's testimony is that he doesn't recall having the conversation, that is materially different than testifying that the conversation did not happen?
Yes, I would agree with that.
Okay.
Although I would stand by my position that
That it didn't happen.
it didn't happen, and that plaintiff had been told, use one of these ladders. If you need a ladder, here they are. They're available for your use. So I think the plaintiff's testimony that he asked for a ladder is irrelevant to the question here, because there was testimony that a ladder was available, and he knew where it was, and he knew that he could have used it if he needed it.
So doesn't that goes more towards comparative fault, which doesn't apply in 240, and less on sole proximate cause when you have that kind of situation? When he was told that there were ladders available, he asked for a ladder, he didn't get a ladder, he went ahead and went on the bucket and fell off the bucket. That's more like comparative fault, whereas if a sole proximate cause situation is he's already been told about the ladder, doesn't ask anybody for a ladder, doesn't talk to anybody, gets on the bucket, falls off the bucket. That's more closely to sole proximate cause because he knows about the ladders, he knows where the ladders are. Yeah, I'm gonna go on the buckets anyway. That's a little different when you inject into the scenario, the supervisor.
Understood,
More
Judge.
comparative, less sole proximate
I
cause.
still think it qualifies as sole proximate cause because the ladder was available and he knew per the foreman where they were.
Right.
And under Cahill, that's all you need.
But how do you reconcile his testimony that he asked twice for a ladder and that he looked for a ladder and one was not available?
There's a complete contradiction, I believe, in the testimony between plaintiff and Madden on that particular fact. And I think that leads to a question of fact. Plaintiff said he asked for a ladder. Madden said he never did, that he had told plaintiff, the ladders are here, if you need it, use it. It's my understanding under the cases of Robinson and Montgomery, the worker does not need to ask for the ladder if he knows where they are and where he can get them, and they're available at the time of the accident.
Okay, thank you.
Thanks.
May it please the court, just in furtherance of what Mr. Orlando has argued, plaintiff did in fact know where the ladders were, know they were stored, they were available to him, regardless of whether or not he had asked for them.
Right.
The issue here regarding whether it's comparative negligence or sole proximate cause is that Mr. Linares could have clearly waited for the ladder rather than proceed forward by stacking buckets and standing on them.
Well, he said that he asked, I think, maybe the day before and that day, and they never brought it. So was he supposed to sit there for 2 days waiting when he was told that the work had to get done?
No, he could have availed himself of the ladders that were available, which Mr. Madden had in conflict testified that there were, I believe, more ladders than workers for that day, and he could have gone where he saw the ladders that morning while they had their morning meeting and grabbed a ladder, taken it to his apartment. That's why there was no ladder there, because he never took one, and then reached the height.
Was there anything of record to quantify the number of ladders? I know what Mr. Canavan said, and I know what Madden said on behalf of Tomac.
There's
But I
nothing
didn't see anything which said, okay, we have 6 ladders or 10 ladders. Is there anything like that in the record except their own response?
No, Your Honor, only their testimony.
Fair enough. And
Testimony.
again, on the record, 822, 823, which is a critical point where the plaintiff made it very clear that he had requested on day 2, day 3, and no ladder was forthcoming. Do you have a different read of that page where Madden says, I can't recall these conversations, versus your friend who said, never happened?
Well-
And in the face, as my colleague pointed out, if the plaintiff's testimony is the only thing on the record that says I asked for it and waited for it and never got here, then you don't have a meaningful opposition to that point, correct?
Your Honor, I do have meaningful opposition to that in essence that the court is allowed to discredit incredible testimony, and plaintiff's testimony that he says, I asked, there were no ladders. There was this whole project there with ladders and workers and taping and spackling, and I find it incredible that there'd be no ladders on site for him to use. And again, we find it to be a question of fact as to whether there were in fact ladders for a jury to decide, because again, I find it incredible that there were no ladders. Capital went to the site, had a president who also testified based on his investigation that ladders were provided, Tomac did have ladders, and that it was the poor judgment of Mr. Linares.
I'm sorry, just one follow-up.
at a
on that.
time.
Is it conceivable that with the number of work crews, because there are multiple jobs going on, and as much as, this wasn't the only job there, correct?
Well, it was the only job where they were taping.
That he was, but my point is if there were other crews there and there were other uses of the different ladders, it's possible there was no ladder available for him because we don't really have a record of how many. In other words, the statement that was said here, that there's more than enough ladders for whomever needed them, can't be verified on paper. It's what you folks say. And let's say there weren't enough ladders and they were all in use so that none were available for the plaintiff.
We find that to be a question of fact, Your Honor,
Okay.
and credibility.
Oh, I'm sorry. Okay, thank you.
Thank you.
have
Thank you, Your
rebuttal time.
Honors.
Good afternoon. May it please the court. Michael Cassell for the plaintiff respondent Jose Linares. As we set forth in our brief, this is
So plaintiffs, It's not my understanding that plaintiff alleged that there were no ladders. It's my understanding that he's saying that there were that there were 2 ladders on site, but that they were being used by other workers at the time. Is that your understanding?
Correct, yes.
And what do you make of your opposing counsel's position that the conversation with Madden about requesting a ladder is immaterial because he knew where the ladders were and he should have gotten one?
Sure, under the labor law, I'm not sure whether they're arguing sole proximate cause or recalcitrant worker, but certainly in the
Goes back
Lamachi,
and forth, it seems like.
it
right?
does seem. I have the Lamachi decision, which was before this court a few months ago, and the court said very clearly, which is under the labor law, the statutory obligation rests with the labor law defendants to provide the employee with the appropriate equipment.
So the plaintiff shouldn't have to be running around looking for the ladder that he needs to use.
Exactly. You can't foist the job of finding the safe equipment onto the plaintiff. The best case scenario here is, assuming all of what they say is true, that my guy had to realize to go down to take an elevator down 4 floors and maybe there was a ladder there. As the court pointed out, I deem it uncontroverted, my client's testimony, that there was no ladder. Madden says on one hand there was ladders in this room, but also says it was my job to make sure all the employees had the ladders. I knew every ladder that was taken out. I visited the workers.
And didn't they also say it was their job that if they saw anybody that would have been standing on these buckets, they would have stopped it right away because that was clearly an unsafe method?
Correct. Accident happens at 3 p.m. in the afternoon. He's working all day without a ladder. There was no ladder provided. He can't be the sole proximate cause. He can't be a recalcitrant worker. As a recalcitrant worker, as in the Lamachi decision, as this court aptly stated, they need to show my client ignored an immediate instruction to use a ladder. There's no instruction.
Or if there's a ladder there, he decides not to use it and stand on the buckets.
Exactly.
But we saw no ladder there. I mean, I think that's controverted.
There's no ladder there. There's no ladder on the floor.
You know, going back to the sole proximate cause issue, I think, you know, without the Madden injected into the picture, there could be a sole proximal question because the worker knew about the ladders, knew about where to get the ladders, X, Y, and Z. But I think when you put Madden in there and him not recalling what happened, that's a little bit of a wrinkle to the sole proximate cause, right? Don't you think? I mean, in my mind, it is.
In my mind, number one, Madden doesn't rebut the testimony, and number two, Madden's testimony, and even from the boss of I believe it was from Tomac's boss, who said Madden was tasked with making sure workers had ladders, which is consistent with the labor law. My client is working until 3 in the afternoon. There's no ladder provided. It's obvious there was no ladder in the area. Even assuming, and of course, interpreting all the facts in light most favorable to defendants, my client cannot be the sole proximate cause. He's not a recalcitrant worker. The decision should be affirmed. Thank you.
Thank you.
Your Honors, just very briefly, there was a question asked as to the quantity of the number of ladders that were available at the time of the man's accident. And if you look at page 792, Mr. Madden's testimony, he said he went to the shanty room immediately after the accident, and there was at least one ladder, one A-frame ladder, in that room at that time. So there was testimony that there was a ladder available in the shanty room at the time of Mr. Linares' accident.
Well, that may be the case that when he went to look in the shanty, there was a ladder there, but we don't know in terms of how long that ladder was there for, right? I mean, someone could have walked back there 5 minutes before, just literally before Madden gets down there and puts a ladder in there, right? So you can't, it's not like you gotta do a time clock check, you know, check in, here's the ladder is here. I mean.
Understood. He also gave testimony that there was at least one ladder available for each Tomac employee on the job site that day.
Okay.
So there was that testimony as well.
Great, thank you.
Thank you.
Briefly, Your Honors, in addition to all of the other testimony, Mr. Linares himself testified that to do so, to do what he did, stand on buckets, he knew it was unsafe, and he did it anyway. And in terms of the availability of the ladder, it really wasn't a difficult task
Well,
for
his
him.
explanation is he did it anyway because he wanted to get paid. I mean,
Correct. Correct,
it wasn't that he was just being like some sort of, you know, acrobat or something.
No, Your Honor. However, he did know it was unsafe, and yet he proceeded to do it with the knowledge that there were ladders available, which he was told for 3 days.
Okay.
Regarding the availability of the ladders, getting on an elevator, grabbing a ladder, and going to your floor, I would not think that that's a difficult task for him to do as a contractor, a construction worker, and it was readily available, although not on his floor, available to him. Thank you, judges.
Great, thank you. Thank you. Okay, next case up is 1140 LLC versus May Studio. Okay, counsel, you're up.
Thank you. May it please the court, Jeremy Cohen of Seyfarth Shaw for Appellant 1140 LLC. I have 6 points that I would like to make. None is genuinely disputed, and that's why partial summary judgment should have been granted. My first point, it's undisputed that the tenant stopped paying rent in 2021 and then vacated its leased premises 3 years before the end of the lease term. Failure to pay rent, vacating early is a breach of the lease. That was enough without more for the court to have granted summary judgment as to tenant's liability. Second point.
That's the pre-surrender, right? What are we talking about?
Well, I'm talking about, no, that's just a breach of the lease.
Right,
We're not- I'll get to that in just a moment. My second point is that the guarantor didn't pay the rent that was due prior to surrender, as he was obligated to do. That's a breach of the guarantee. That was all the motion court needed to grant partial summary judgment as to guarantor's liability. So now, Justice Owing, I'll get to the point about damages, my third point. So there's
The meat part of the case, right? Your money.
so there's 3 categories of damages here. There's the pre-surrender rent, there's the rent that accrued post-surrender through the end of term, and then there's attorney's fees.
So there's no dispute based on the record that the tenant admitted or conceded as to paragraph 25 to the material facts, that the pre-surrender rent of $197,000 and change was owed. True?
Absolutely true.
That's like a slam dunk.
Should have been.
Should have been.
And hopefully will be for this court. And
I don't know, you get a good block shot. I don't know if it's going to be slam dunk,
I should
but
say,
okay.
if your honors see, I have sprained my thumb playing basketball on Sunday, so I don't want to.
You see the two of us when we play one-on-one. Go ahead.
But the point I want to make there that I think is also important, I believe counsel is going to tell you that that obligation is only of the tenant, not the guarantor, that the guarantor has some lesser obligation. Absolutely not the case. The guarantor's obligation is identical up to the surrender date as that of the tenant. So that's point 3. Point 4, post-surrender rent. No question.
Is there any dispute at this point as to the surrender date, or does everyone agree that it was that June 21st, I think it was 2021?
I want to be a little careful about the word we use. There's no question that's the date they left, okay? I believe counsel is going to tell you that we accepted the surrender.
Right.
We did not, okay? That was the day they left. That's the day of the surrender for purposes of the guarantee only. That's the day that Mr. Meese's personal liability under the guarantee ended. But as far as the tenant and also the assignee are concerned, the obligation to pay rent continued through the end of the term, which was just last month in January. That's under Holy Properties and this.
Subject to what offsets there may be.
Correct, no question. And that's part of why.
There'd have to be a hearing on damages.
Exactly. That's why we didn't put in proof of our.
So why do you say that what you did or what the landlord did, you know, there's such a thing called no good deed goes unpunished, doesn't qualify as a surrender for them?
No, but
they said you helped them move and everything. You were very nice about it.
that wasn't the good deed.
Okay.
Well, the good deed was we gave them a rent deferral during COVID. And we said, we'll defer your rent and make other accommodations. And
Well, why don't you think that all factors into whether or not there was a surrender, or there's a factual issue of whether or not there's a surrender?
because under Article 25 of the lease, and I apologize.
Long way to getting to what I wanted as an answer.
We put in our papers Article 28. It's one of these Rebney leases that it's a little
You
hard to
could barely see it, but it is 25.
It's 25, yes. 25 says it has to be in writing. There's no evidence of a writing. In fact, we had already sued them by the time that they purported to surrender because they had already stopped paying rent. So there's no
At the
surrender.
end of the day, if arguably you're entitled to pre-surrender rent, conceded, post-surrender rent to be determined, then you're a prevailing party entitled to fees.
You've articulated point 6 for me very
I told
well.
you you read everything. Thank you. Okay, counsel, you're up.
Good afternoon, Your Honors. May it please the court. My name is Lloyd Feld. I'm here on behalf representing the defendants, respondents. I only have one point to make, well, maybe two. The guarantor never admitted anything. The guarantor did not admit that he was in breach of the guarantee. There's no evidence or allegations, but there's no evidence that the guarantor did breach. But more importantly, the guarantor has denied that he had had the amount of monetary liability that the appellant claims. Now, all of this is pretty well covered in my papers. The only point that I'd like to make at this time is that in the appellant's reply brief, he claims, or it claims, that because the guarantor had guaranteed the obligations of the tenant and the assignee, the fact that the tenant admitted the liability for approximately $200,000, ipso facto, the guarantor is liable for that $200,000. But the guarantor is a different party in this litigation from the tenant or the assignee.
Can I ask, what is the purpose of the guarantee then?
Beg pardon?
What is the guarantee then? What were they guaranteeing?
They guaranteed the obligations under the lease, and I'm not disputing that. What I am disputing is that the court has to recognize without any discovery at all that because the guarantor guaranteed the obligations under the lease and the tenant admitted that that liability by the tenant is $200,000, that automatically becomes the guarantor's liability for $200,000. Now, that's what I call sleight of hand.
Well, I mean, if a court were to find summary judgment against the tenant and the assignee for a certain amount, and if they didn't pay it, they could then go to the guarantor because the guarantor would be guaranteeing the responsibility of the tenant and the assignee. Why isn't it the same? If they admitted that they owe it, they come in and they have a responsibility. They don't exist in and of themselves, the guarantors.
With respect, Your Honor, the tenant admitted the obligation. The landlord doesn't. But on the appellant's theory, if the tenant had admitted that the liability was $500,000, that would be binding on the guarantor. And that's not what you can do in this situation. So essentially, that was the only point that they made in the reply. Everything else, I believe, is covered in the briefs. I just wanted to address what I call leisure domain, if you will.
Thank you.
Thank you.
I believe counsel misunderstands what our position is. In the response to our statement of undisputed facts, all defendants admitted that the amount the tenant owed prior to the surrender date was the $197,000 and change. All defendants admitted that. Once we admit that that's the tenant's obligation pre-surrender, we know that that's the guarantor's obligation for pre-surrender as well. If the court has nothing else, that's all I've got.
Thank you.
Thank you.
Sticky's Holding versus Abrahamian, I'm sorry. Okay, counsel.
Proceed. Good afternoon, Your Honors. May it please the court, Martin Karlinski on behalf of the appellant, Paul Abrahamian. As the court knows, this case arises from a contractual non-disparagement clause. Motion term denied our motion for summary judgment, and this appeal follows. The appeal calls upon the court to decide two matters. One, what is the definition of disparagement for purposes of a non-disparagement clause based in a contract? And I stress that because I I keep wondering what we would tell the jury, or what the court would tell the jury. What are the elements of disparagement? And I have answers to that, and I hope the court will address it. And second, the second issue, whether Sticky's claims and supporting evidence are sufficient to withstand summary judgment and proceed to a trial on the merits of breach of the non-disparagement clause. Your Honors, there's several definitions of disparage or disparagement. Black's Law Dictionary defines it as to speak slightingly of, to criticize someone or something in a way showing that one considers the subject of discussion neither good nor important. Also, to degrade in estimation by disrespectful or sneering treatment. Relatedly, it says disparagement means, quote, unfairly castigating or detracting from the reputation of someone or something. I turn to what I think is the next element, again, as if the jury were being charged on how to find this. And I should parenthetically say, Your Honors, that I don't think jurors know what disparagement is. I mean, we may think we do.
That's not our problem right now, is it?
Not immediately.
You're only appealing the portion of Judge Schechter's order which denied you summary judgment on this one issue.
Exactly,
right?
Your Honor.
And why, I mean, I read all the papers and the briefs. Why is there not enough there to hold that, at least to present to a jury? You'll have to help the judge charge the jury. The judge will figure out how to charge the jury. But right now, why are there not issues of fact based upon all of the actions that have taken place?
Your Honor, the answer to that is that virtually everything that is in Sticky's papers in opposition to this motion for summary judgment is not actionable disparagement. And I can show the court that by going through the now five instances that they identify as episodes of disparagement in violation of the contract. The first one, the November 2019 email, says only, we're going through a business divorce and stay tuned for interesting information. How is that susceptible of being disparaging? A meaning that slights its object, just not there at all. It doesn't.
Well, you know, again, I'm going back to this paragraph 3A, which is the clause that we're talking about. And it says that that your client shall not make any statement, direct or indirect, that objectively, that is in the view of a reasonable third party. And reasonableness is usually something that we don't decide on a summary judgment motion, but that we leave to a trier of fact. And it seems to me that would, reading all of the situations where he went into the store, he stayed there for hours, he got involved, he walked in the back, he got involved with photo shoots, he made all these comments. All of these allegations, it seems, at least holds him in to see what the jury would ultimately determine.
Justice Chapnick, there's a reason that we restricted this appeal to the question of non-disparagement or disparagement. And that is because we believe it presents a very clear-cut, non-factual legal issue. Now, this November 2019 email illustrates that. The other instances that Sticky's identifies in its opposition are more or less the same. Criticisms of management. How does that amount to disparagement? Mr. Abrahamian is a 10% owner of this company. He co-founded it. He's allowed to criticize its management, certainly, and that doesn't pass the boundary and become disparagement. Another instance that they identify, although I do see that my
Counsel,
light is...
we have all the instances.
You do, you're right.
You have rebuttal time. Thank you.
Thank you.
Good afternoon, Your Honors. Brian Brick from Brick Law PLLC for Respondent Stickies. To continue with Justice Kapnick, the record does have a number of instances of the conduct that was testified to by all of the deponents.
In my mind, all you need is one, right? Because
That's right.
You can't disparage the company and say 1, 2, 3. One time is good, right?
That's precisely right. And there are 35 pages of the record where 6 of the witnesses talked about these instances. And while a number of them said, well, I can't remember the specifics because there were so many, they all said the same thing, that they remembered Mr. Abrahamian saying negative things about John Sherman, about Michael Sherman, about the company. And he also made, there are other allegations of sexual misconduct. There were,
Well, sexual orientation too, I believe,
well,
right?
and the question that was asked was, well, why is that disparaging? The orientation itself is not. But when you're making those allegations about someone who's in a committed relationship, that's an allegation of infidelity, and that is absolutely disparaging. But beyond the point is, the claim below is not a tort for disparagement, it's breach of a contractual provision. And so the standards are going to be very different. The summary judgment burden that the appellant had was first to establish that there is absolutely no issue of fact on the points that he was raising. He didn't even do that. So the burden never shifted to Sticky's to have to demonstrate its prima facie case, even though it certainly is existing in the record.
The counsel is trying to point out, I mean, attempting to show that all the comments that are alleged to be disparaging are not actually disparagement. And it's like my colleague says, that's really sort of weighing a lot of like, what is this really trying to say? Because it's not clear that it's not disparaging. It's not like these guys are terrific people. I mean, right? I mean,
Well, that's right. All of the witnesses were asked, or most of them were asked, what's your view of what disparagement means? And they all said something to the effect of it's negative, it's connotation where there's a bad, implication of what you're saying about the person. They all seem to have a relatively consistent understanding as a layperson. And that's really what the jury is going to be asked to do, what they should be doing. Because otherwise, what the appellant is asking the court to do is make credibility determinations about the witnesses, and that's inappropriate on this motion. So, I just want to mention one point that we highlighted in the brief, the email, the November 19th email. While the statements themselves do not contain necessarily the defamatory material, there is an implication that there are facts underlying the opinion that's stated. And this is the Davis versus Boheim case that says, when you have the insinuation that there are facts that are defamatory or disparaging underlying and supporting the opinion, but you haven't disclosed those facts, that is actionable. It's a mixed opinion. And so that certainly is something that could support the breach of the non-disparagement clause.
thank you.
Thank you very much, Your Honors.
One or two small points, Your Honors. First of all, in 35 pages that witnesses testified about disparagement, not one of them could remember the words that Abrahamian used. Not one of them, not a single one.
Well, in defamation, you might have to do that. Do you have to do that for disparagement as well? Remember the exact words?
Your Honor, I think you do. I really think you do, because otherwise you cannot evaluate it. I mean, certainly no jury verdict would be upheld if it's simply found on the basis of no evidence that lay people concluded something was disparaging among other things that were said. That's an untenable holding.
And I know that some people saw videos. I tried to find them. I don't think they got up to the appellate division, at least as of before we got here today, but I did try to find them. But there are also videos here that help support some of the claims, apparently based upon what everybody said was in the videos. I have to admit I didn't see them.
There are, Your Honor, and the videos are irrelevant, the disparagement claim.
Okay.
They don't show anything, even beginning to
Thank
get
you. We'll
there.
take a look at it. Thank you very much, counsel.
Thank you, Judge.
All right, next case up, Duha versus Martinez. I am recused from that matter. Justice Kapnick will be running the clock. Thank you.
So I just didn't want to knock that over. That's all. Okay. You may begin. Good afternoon.
Good afternoon, Your Honors. I'm Mark Itzoni. May it please the court. From the law office of David Offlaw, PC, representing the appellant's plaintiff, George Duha.
Isn't one of the critical issues here the inconsistency between your client's deposition testimony and the affidavit prepared in opposition to the motion for summary judgment?
Not at all.
Oh, you don't find it inconsistent that the deposition where he has absolutely no recall of the accident as the pedestrian dart out, but suddenly in an affidavit in opposition, suddenly he starts remembering, the accident?
Two parts to that. One, there isn't any statement by the defendant about darting out. It's not used.
No,
Counsel,
that's my words. I'm just characterizing, in fairness, I was characterizing because that a shorthand version of what the defendant was saying, that he got past the cab and the guy jumped out in front of the cab, right?
it is one sort of shorthand version, perhaps, but it is not a conclusion that's reached by any evidence in the record. There's no evidence in this record to support darting out, none whatsoever. But in addition to that, more broadly, the point is it doesn't matter if there's an inconsistency between the affidavit and an inconsistency with the transcript, because it shouldn't have been reached to begin with. And that shouldn't have been reached because it isn't the plaintiff's burden in opposing a motion for summary judgment. We are opposing. It's defendant who is moving, and it's their burden. And in order to make an evaluation as to liability, what is reasonable for somebody to do under the situations, what actions could have they taken to avoid that accident, you must, absolutely, so long as we're operating in this universe, you gotta have considerations of time, and you gotta have...
I mean, you seem to have focused very much in your briefs on the court having made a reference to the defendant only seeing the plaintiff 2 to 3 seconds before the accident, right? I mean, you know, that seems to be, and that the plaintiff never said that. That no one ever said that. Wasn't that one of your concerns, that was in the court's decision?
That certainly is a concern, because there is no way the court could have concluded that there were 2 to 3 seconds, 1 to 2, 5 to 10, 10 to 15. It is impossible based upon what is
Also,
in this.
take away that timing issue. The defendant did say that the plaintiff walked right out in front of the taxi and in front of his car, right? Just as he was passing by, that the plaintiff walked in front of his car and in front of the taxi cab. He tried to press the brake. He did. The car slowed down significantly, but not enough to avoid hitting the plaintiff. What's wrong with that? Why is that not enough? In light of the fact that the plaintiff had no recollection of the accident.
Why isn't it enough time? Why didn't he see the plaintiff in enough time?
He did what he could. He applied the brakes. Couldn't
Under
stop
the
the car.
circumstances, he certainly did. Why was he in those circumstances? We don't know. We don't know if it is his inattentiveness. He's not letting us know. He's not letting us know how much time he saw him before or what distance separated him.
So you're saying he has to so when he sees plaintiff walk out from in front of this parked car, he has to look at his watch to see how much time he has before he applies the brake? He said he applied the brakes. Car couldn't stop. He was too close. There's nothing to dispute that. That testimony gives the indication that he saw the plaintiff, did what he could, pressed the brakes, wasn't enough time, hit him.
It gives an indication, it gives an implication, but does it determine that as a matter of law? No, certainly not. Could somebody come up with another conclusion? Yes. Did they
Based on what? The plaintiff did not recall.
The plaintiff did not recall, certainly, but the state of the law isn't that if somebody is rendered unconscious or killed, that a person who strikes him with an automobile has carte blanche to say whatever it is they want.
Let's hear from your adversary. You'll have a few minutes on rebuttal. Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Michael Mernon for Defendant Respondent Rodolfo Martinez. I think, Your Honor, you seized on the nub of this. The defendant testified under oath at deposition in 2 places in the transcript, and I think you were quoting. I then passed, as I was driving home, I passed the intersection where the pedestrians were allowed to walk. No one was there. I then passed what was a parked taxi cab on the right side, and as I was going by, I saw someone just walk right out in front of the taxi and right in front of my car. I tried to brake, but I had no time to really stop before hitting them. Again, a few pages later, so the pedestrian stepped out from in front of the parked car? Yes, right as I was passing by. Right as you were coming through? Yes. You hit the brakes? Yes. There wasn't enough time to stop before the impact? Plaintiff's counsel asks the leading question, and the defendant replies, yes.
Now, of course, if the plaintiff had been able to testify differently and given some other factual, raised some factual issues, that might be a problem.
Right.
But the point was, I read the affidavit where he testified, the plaintiff, that he remembers walking to an ATM, I think a very long walk to an ATM, and then the next thing he remembers was waking up in the hospital.
Right. Now, Your Honor, also, and it may not be highlighted in the record, but it's in the record, it's in the deposition testimony. Plaintiff was not rendered unconscious or disabled by the accident. Plaintiff just did not later remember. He remembered the ATM. He did not lose consciousness at the scene. That's in the record.
Was there anything in the record in terms of alcohol?
It's not, there's speculative testimony, but I don't think we've reached a point in discovery where that's, admissible in the record. The other point, though, is he did offer one glimmer of testimony about the accident, and that was, I think the quote is, "It happened so fast." Entirely consistent with what defendant testified to is, I passed the intersection, and then right there's a taxi park. And plaintiff's suggestion that, well, maybe it was 15 seconds. Well, why not 30? Why not a minute? Well, we know that it wasn't because the police report's in the record, and you can at least glean, we're talking about a circumscribed space. This couldn't have happened with, minutes and quarter miles of travel. This is past the one intersection, guy steps out in front of the cab, the accident takes place. It's not defendant's burden to hypothetically review all possible timelines and exclude anything that is potentially negligent on his part under questioning.
Does a pedestrian violate vehicle and traffic law if they walk out into the street in between parked cars?
Yes, yeah. And they were outside the crosswalk in this case.
Thank you. Counsel, you have 2 minutes.
First, Your Honors, there is no mention of crosswalks in the record. Word doesn't appear, outside of the appellant's briefs, of course. The area where the pedestrians are supposed to walk, things of that nature, are in the record, whatever that means.
Oh, it does say that, I think that testimony of the defendant at a certain point said something about that it was past the area where the pedestrian was supposed to walk. It sounds like a crosswalk, didn't use the word.
It's Post Avenue in Westbury. It is what it is, and he didn't use the word crosswalk, but nonetheless, the testimony is that he said that I didn't go more than 30 miles an hour while I was on Post Avenue, so this didn't happen as a immediate turnoff. Okay, he was on Post Avenue for some time. In addition to that, he wasn't coming out from between two cars, he was coming out from in front of one, which kind of indicates that there was no other car which would be to his right. Nonetheless, it all comes down to the fact that we still don't have time or distance offered. Two critical things to determine whether somebody had enough time to act. You can't make the determination whether somebody did what they were supposed to do unless they show that they had enough time to do it or did not. He says, I didn't have enough time. But why was he in a situation where he didn't have enough time? The reason was because he didn't have a lookout. That's why. He didn't see what there was to have been seen, which was my 6'5", blonde-haired client entering the roadway. And there is nothing in this record anywhere that shows darted out.
Okay.
With that, I rest and I thank Your Honors. I thank my adversary. Thank you. Have a good day.
Thank you. We'll take a look at the record again. Thank you.
Thank you.
The next case for argument is Patrick Capital versus Rabina.
Thank you. Thank you, Justice Kapnick.
Thank you, Justice Owen.
Patrick Capital. Oh, she even set this up.
Of course. Good co-pilot.
The record. Okay, counsel, you're up.
Good afternoon, Your Honors. My name is Martin Kafafian, the law firm Beatty Padavano. I represent the appellant, Patrick Capital Markets, LLC.
So the essence of your appeal is that you believe Judge Schechter erred in not interpreting the emails 393 and 252, I'm using them colloquially, but you know what I'm talking about, and somehow constituting a modification of the placement agreement that warrants them getting a finder's fee for 520.
I think there are two distinct arguments around that, and maybe I'll take them apart if that's okay. The first argument arises out of the Court of Appeals teaching in Rose versus Spa Realty Associates. And what the court says in that case is that assigned writing plus an oral modification plus part performance takes the transaction out of the statute of frauds. So under that theory, we don't even have to get to what the 520 confirmation email meant, because there's sufficient allegations and evidence in the record with respect to A, oral modifications of the contract to include that transaction.
Well, hold on a second. We should also preface that by saying that the placement agreement did not involve the parties that you're seeking to hold liable for any fees, right? Because the placement agreement was between Patrick Capital and the other company, Ascend, right? I know Ascend is sort of an affiliate and ultimately became part of Rabina, but I looked in your complaint and there was no allegation of alter ego or piercing the corporate veil. So those are two separate entities in my mind, right?
So
so even putting together and agreeing with you with all the Court of Appeals precedents, you got two different people here, two different companies.
So I think this court's decision in Horsehead Industries versus Metal Gesellschaft, this is briefed at page 23 of Appellant's brief, addresses that particular issue. And what this court said in that decision is that a parent company can be held liable as a party to its subsidiary contract if the parent's conduct manifests an intent to be bound by the contract, and the intent is inferable from the parent's participation in the negotiation of the contract, a second factor which I don't think matters, and a third factor, or if the subsidiary is controlled by the parent for the parent's own purposes. Now, if we look at the complaint, what's alleged in the complaint?
Well, that sounds like a lot of alter ego and a lot of piercing corporate veil kind of issue, right? That sounds like that's where it's headed. When you make those comments, or when you're looking and reading the case, right? Am I correct?
That's correct, Your Honor.
So in this case here, like I said, I didn't see those kind of allegations in your complaint here of control, of taking over, running the shop, basically being the alter ego of Ascend.
Well, Judge,
Did I miss something in your complaint?
I can direct the court to pages 63 and 64, 48 and 49, 56 and through.
Of what?
Of the appendix. And the allegations specifically, I mean, there's a part of the complaint that talks about alter ego. It's a heading. But with respect to the allegations particularly, you've got Joe McDonald as the person authorized to bind both Ascend and both Rabina. He's the chief investment officer. He's sending emails from his Ascend account. He's sending emails from his Rabina account. We're at the pleading stage here. I mean, we haven't had the opportunity to depose him. We don't know anything about the org chart. Defendants put in the record Form ADV.
What is clear, at least in my mind, is there's been no written modification or extension of the placement agreement, as we would say the traditional formal way one would do it, correct?
Well, Judge, I would direct the court to page 298 of the appendix, which is the 393 confirmation letter.
The 393 was a separate agreement. There was a one-shot or one-time payment of $150,000 that was agreed to in that case. So let's go to 520 because that's what you're seeking. You're seeking a finder's fee because you claim Gallagher brought Abraham Capital to put all that millions of dollars into that building. And you think based on the way it worked in the placement agreement, you should get 1.5% of the investment. When it is recognized that the 520 deal was not part of Schedule 1 or 2 of the placement agreement, and you dealt with an investment principal that was not one of the scheduled investors, correct?
That's correct, Your Honor.
Totally different.
Yes.
And so that's why I started my question to you. Is your view that the so-called emails that were going around and the conversations on the 520 deal between Gallagher, Vitale, and McDonald, that somehow bring in Patrick Capital to get the finder's fee? That's your position.
So
and
again,
as
Your Honor, I
I
just wanna
read the colloquy before Judge Schachter and her responses, Nothing about alter ego. Nothing. I didn't read any of that in the 25 pages of that, in that back and forth, that kind of analysis. And the court was pretty clear in saying, I just don't see the writing that's required here, unless I misread the transcript. I don't see the writing that the placement agreement requires for it to have been a modification and somehow applicable to the 520 deal, correct? Did I get that record right?
So, Your Honor, I was retained after the appeal was filed, so I wasn't there. So I have the same sort of advantage that Your Honor has. But to answer your question, I just, again, want to lay one more foundation.
Well, you got the record that he has. You have the same record, right?
Absolutely, Your Honor.
You weren't there either. I mean, not that.
My colleague here was, but
Oh,
yes.
she has a chance to respond to everything.
But just to respond to your question, Your Honor. So first, we don't think we need a writing because of what Rose v. Spa Associates says, okay? But if we needed a writing, we have the 520 confirmation email. Now, let's look at what the trial court did with the file.
520 confirmation email, and if I'm wrong, correct me. Is that the one where McDonald says to Gallagher and Vitale, we're not trying to go around you somehow, we'll get back to you, we'll circle back to see if something can be worked out? Is that the one you're counting on? Which to me sounds like it's an agreement to agree possibility, but not an actual, if it goes that far, but not an, and it doesn't mention Patrick Capital in the email, it mentions Gallagher and Vitale.
So, Your Honor, my client...
And on top of that, the email was sent to Lou, purportedly Lou Vitale, and wasn't sent to, and was only copied to Gallagher email, his email handle, not the, which is Fidelity National Financial, not to his, not to plaintiff's email, so.
So just by way of background, Your Honor, Gallagher has a long relationship with Rabina as a broker through FNF, so oftentimes the email was, auto-populated, but again, we haven't even got the discovery yet, so all these issues will be flushed out. But to respond to your, and the second point I think Your Honor raised was that Lou Vitale copying Kevin Gallagher. Lou Vitale is a business partner of Kevin Gallagher. The placement agreement itself says that Kevin Gallagher can go out and work with other people if he wants to. As long as he's involved, he's involved. But Your Honor, let me address the question you've asked head on.
Okay, you can do that in rebuttal. You can do that in rebuttal.
Yes, Your Honor.
Have a second. Thank you.
Good afternoon, Heather Robinson from Herrick Feinstein. For Rabina Properties, Maydad Rabina and Josh Rabina.
Was there an agreement? Was there a modification? Do you owe them money?
No.
No, right?
No. But there is one point that I would really like to address, and that is, it was in the papers and it was also here at argument today. And there's been what I believe a conflation by plaintiff's counsel of two different provisions of the General Obligations Law. There are two separate provisions of the General Obligations Law that support dismissal of this case. The first provision of the General Obligations Law is 15-301-1, which has nothing to do with finder's fee agreements. It just relates to written agreements that say on their face that you can't modify this written agreement without a writing. Doesn't matter if it's a finder's fee agreement, doesn't matter if it's another type of agreement. And we hear today that the statute of frauds has been overcome. That's General Obligations Law 5-701A10 under the Rose versus Spa Realty case, because there's assigned writing and oral modification and par performance. And I just want to tweeze that out for the court because I don't know that it came through clearly in the papers. General Obligations Law 15-3011, as I said, relates to a writing that can't be modified absent a writing. In that situation, the court has said in Rose Spa Realty and other cases that if you can allege an oral modification and par performance, you might be able to come out of that writing requirement, okay? I don't believe they've alleged an oral modification anywhere in the complaint. I don't believe that they've alleged any conduct that's unequivocally referable. But let's pretend for a moment.
Are they referring to the deal with 393 and how that went down? I mean, is that part of what they're referring to, which I don't necessarily think works, because I think that they didn't even get the 1.5, if my math was right. They got a different number. It was just sort of a one-off deal. Here, thank you very much. We're happy to have done business with you. We want to give you 150,000.
I agree with the court that that's a one-off deal, but they have alleged that that's part of the
A
conduct.
continuing type of situation.
Something that, or like partial performance that might lead you to try to come out of the statute.
Right, and I believe that it kind of comes out on the other side of that coin. I believe that it kind of shows that when the parties intended to have a monetary payment for a separate deal, they knew how to address that. But separate and apart from that, I don't believe that they've overcome the requirements of general obligation law 15-301. But even if you pretend for a minute that they have, there's a whole separate hurdle. And that's the statute of frauds under general obligation 5-701A10, which for a finder's fee contract requires a writing. Full stop. Now there's this argument that SPA Realty also applies to that. That's not what SPA Realty is about. It's not about a finder's fee contract. It's about that separate section of the general obligations law. The section 3011 was...
So finder's fees is still locked down. You got to have a writing.
I believe that to be true, and I believe that the court needs not look any further than the Snyder case that was addressed by the IAS court, and that is in everyone's brief here. That's a Court of Appeals case. In that case, and in every single case when there is an allegation for a finder's fee, absent a written contract, the plaintiff stands up and alleges, I was promised to be paid, and guess what? I did the work.
There's a reason for that.
There's a reason for that.
And so it's like the finder's fee has to be in writing, period. There's no continuation like there might be with other types of agreements that could be orally modified, possibly.
I believe that to be true. I believe that Snyder supports that, and I believe that also Daydu supports
You know,
that.
the problem I have, at least my observation, is this placement agreement was so clear as to what the purpose was with respect to, it was with Patrick Capital, and it was with
Ascend.
I can't remember that. Ascend. And then you have these red line, at least I thought I saw in the record here, red line. It's a complete rewrite of the agreement, right? I mean,
It's a different agreement. It's not
it's
a
a
rewrite
total
of the
different, I mean, as my colleague pointed out, there were two specific objects or purposes of that placement agreement. The fifth app, this 520, doesn't fall into the two, right?
I believe that to be true.
Unless I'm missing something.
I don't believe you're missing something. And there's one more point I would like to address, and that is this alter ego issue that the court rose. There's two different issues in the writings, in the motion papers and in the complaint. There's this idea that plaintiff is proffering that Rabina and Ascend are alter egos of each other. That's not what the claims against Maydad and Joshua Rabina are about. There has to be a pleading that Rabina or Ascend are alter egos of the individuals. And to do that, you have to have a misuse of the corporate form for personal gain. You have to have a misuse of corporate funds for personal profit. You have to have the misuse of a corporation as a facade to commit a crime. None of that's alleged in the complaint. And it's not really argued genuinely in the appeal papers either by plaintiff. What's really argued is this unity of Rabina and Ascend. And that still doesn't support a claim against Maydad or Joshua
That
Rabina.
there's a unity doesn't necessarily mean that one is going to be liable for the other's debts.
Separate from the fact that I don't agree there's alter ego adequately pled against the entities, that's not what the issue is as to Maydad and Joshua Rabina. It's a very different issue. I don't think it's adequately pled, and it's not briefed in any sufficient form to overcome the motion to dismiss.
Okay.
Thank you for my time.
Okay, now you can answer the question. Now you had time to think it over.
Your Honors, 3 quick points. The first to respond to the last thing my colleague said. We're not seeking to impose alter ego liability here. We're arguing that the parent adopted the contract that its subsidiary had signed. That's the argument, which is different than piercing the corporate veil. Okay, that's number 1. Number 2, Justice Kapnick, you had a question about 393 or a comment about the 393 agreement. That document starts by incorporating and expressly referencing the placement agreement. That's the first paragraph of that document. I just wanted to point that out in the record. And it says, and the parties sign and agree, that it's been amended, restated, supplemented, and otherwise modified from time to time. So that's in the record. And then to respond to, or to return to where we started. So the trial court makes a determination as to what that 520 email means. We have an allegation as to what that 520 email means. It's an allegation that's based on the circumstances that surrounded it and what was happening at the time. And, you know, listen, there's no dispute that the client delivered a $72 million capital equity investment that's resulted in a $2 billion project, 20 blocks that way. That building's going up right now. And Rabina materially participated in that process. They met with clients, they sent NDAs, they sent pitch decks. They worked with each other for months, as they had, you know, over the preceding months with all the prior deals.
Is it your position that that email is definite to be relied upon, that 520 email? Is that your...
Our contention is yes. And then the question becomes, what does the email mean, right? Is it vague? Is it ambiguous? If that's the case, then how could the trial court have made a determination that it meant something else, especially when the trial court didn't have a certification from the sender of the email, and all that was before the trial court was the plaintiff's interpretation of that email, which obviously advances the plaintiff's theory of the case. So again, we thought it was arbitrary and capricious for the court to have reached the decision it did without at least a certification from that email sender. The court has no more questions?
Thank you. Thank you, counsel. Thank you both. Have a good day.
Thank you.